At the A4ID Governance Knowledge Group event on the 23rd of October, Andrew Smith from Article 19 considered the right to access information and how this right fits into the development agenda.
Hi everybody, thank you to Advocates for International Development for inviting Article 19 here. For those of you who don't know, just had an introduction to Article 19. We're an international freedom of expression and access to information organisation established in 1986. We've got, over the last 6 years, have expanded from London to work more internationally, closer to the field. We have offices in Mexico, Brazil, Senegal, Tunisia, Kenya, and Bangladesh. I just spent 5 months in the Kenya office working on an access to information project that we'll come to talk about. And I'm now working as a legal officer in London with our law and policy team, which provides legal analysis and policy advice to the regional offices that are implementing various projects on a broad range of issues, not just access to information and development, but also defamation, national security, freedom of assembly, LGBT rights is another area that we're moving into. So that just gives you a picture of what Article 19 does. We're in Farringdon, come visit us. So today I'm going to speak about right to information, specifically in the context of development, and how international human rights law has come to be understood as guaranteeing the right of access to information, and how that has then been expanded upon to be seen as key in facilitating the people asserting their rights to development and other human rights, not only civil and political rights, but also social and economic rights, and really perhaps blurring that distinction that's normally drawn between those two kinds of rights. So in overview, we'll just talk about what the value of access to information is generally, and particularly in the context of development, where the international instruments come from for securing that right, what we should consider when domestically implementing the right, and the importance of that right to development. And I'll put that into context by talking about the work that we've been doing in Kenya on the rights of internally displaced people to information, and how the lack of effective information flows have really been obstructing the ability of individuals who are internally displaced in Kenya to assert their rights effectively. So talking firstly about the value of information, the human right to access information is really based on the principle that governments hold information not for themselves, but for and on behalf of the people that they govern. One thing that we really come up against with talking to politicians about the right of access to information is when you describe the kinds of information they should either be disclosing as a matter of course or responding to positively from people seeking information from them. They ask, why should I give this information to these people? Like, they have no right to it. And it's sort of, the right really is based on this fundamental premise that governments are serving people, and to underpin all principles of democracy, you have to work on the idea that governments hold this information for people, and the default position should be access, not why should access happen, but why not. And there's various reasons for that. Article 19 is pushed for the idea that information should always be regarded as the oxygen of democracy, and key to asserting all human rights, not only the right to freedom of expression, but participation in democracy and civil society and the goings on of society generally. It's fairly obvious that you have to have information in order to be able to assert your rights. You need to know who the rights holder is. You need to know the nature of the rights that you have, the availability of assistance. And it's only when you're empowered with that information and the processes for implementing that right that you're able to effectively fix any problems that you might be going through. And that's particularly the case for people with acute development needs, as with internally displaced people in Kenya, which we'll come to talk about in a moment. It's also key for accountability and good governance, for open and informed debate, for the media to be able to get access to key government held information and be able to disseminate that to the public. It's key as well to implementing a culture of effective transparency. If you're operating in government and you know that a person can access information held about your activities, you're less likely to engage in activities you don't want people to find out about. And if you work for the media or for an NGO, then having established mechanisms for getting the information that you want from governments is an effective way to hold government actors to account. There's also another case for access to information that's perhaps less of a human rights argument, but countries that have implemented access to information regimes do find that most requests come not only from civil society and the media, but also from commercial bodies and people wishing to do business, especially government contracts. And this enhances not only the flows of information commercially, but has economic benefits that perhaps make up for the costs of implementing an access to information regime, which is one of the arguments that's often advanced against reforming transparency in this area. Okay, so let's talk about the international legal framework. We'll run through this quite quickly. The right to freedom of expression is guaranteed in Article 19, but that right has three elements: the right to seek information, the right to receive information, and the right to impart information. When people talk about the right to freedom of expression, they often think automatically about the right to vocalize something, to impart the information, and not necessarily the right to both seek and receive information from governments. And this is reflected not only in the International Covenant on Civil and Political Rights, but in the American Convention on Human Rights at Article 13. Raised in Chile as a case that Article 19 intervened in over 5 years ago now, which concerned logging in Chile and a environmental group that was seeking information that wasn't getting disclosed to them. And it's an important case because in the inter-American context really established that the right to freedom of expression includes the right of access to information. It's explicitly guaranteed in Article 9.1 of the African Charter on Human and People's Rights. Article 10 of the European Convention on Human Rights guarantees the right to freedom of expression, which is also understood within the Council of Europe in the same context. Have the African Declaration on Principles of Freedom of Expression, the African Platform on Access to Information, which contains more specifically the application of this right in the development context of fostering the rights listed on the screen here. So we have education, healthcare, gender equality, children's rights, clean environment. It's again demonstrates this crossover between what's normally understood as a political right and how it can be used to affect social and economic rights. And that's particularly the experience in South Africa as well, which has probably the most advanced jurisprudence on social and economic rights. That the theory of progressive implementation of social and economic rights is more and more being given this procedural understanding to it, that the right can be effectively implemented where they're providing enough information to people for them to be able to assert certain rights. And that's there's been several cases on that around the right to water and the right of access to health. We also have the Aarhus Convention, which is on contains specific information on access to environmental information. So when we come to talking about the substance of the right, that's sort of the background, why the right's important, where it's guaranteed. There's several principles that really should underpin our understanding of what this means as a legally enforceable right. The basic rationale is the principle of maximum disclosure, which we talked about before, and that is that all information should presumptively be accessible, and that any legislation implementing the right of access to information should make it fairly emphatic that this underpins any access to information regime. So part of that is also having the right to information defined as having a broad scope, that everyone holds that right. Many countries implement the right and only guarantee it to citizens, which is a problem when you come to talking about refugees and internally displaced people, stateless people that might not be considered citizens under domestic laws. It also applies to all information, and it's not compatible with international standards to have a implementation framework that excludes vast swathes of government-held information on like generic grounds like national security, for example. So the other part of the principle of maximum disclosure is that the party seeking to withhold the information bears the burden of proving why they are withholding that information. It also applies in certain contexts to private bodies, particularly where they're substantially publicly funded or receiving large amounts of public money. In South Africa, the South African Constitution also requires private bodies to disclose information which is needed for the protection or exercise of any right, which is why they have fairly progressive decisions coming out of their courts in relation to things like the right to health and the right to water, which are guaranteed in their constitution. The next is the obligation to publish, which is really sort of part of the maximum disclosure principle, that when the right to information is being implemented, governments should proactively be putting information onto their websites and out into the public domain to assist people proactively. In the development context, this would mean things like aid policies, evaluations of performance of what's being implemented domestically in terms of aid, information on finances, the budgets, expenditures, revenues relating to development and the attainment of the Millennium Development Goals, also details of government involvement with the extractive industries, information on contracts, public tendering. Really, there should be schedules in a good access to information law. We'll actually have schedules of what each government department has to release proactively onto its website. These principles apply not only to governments, but for example, Article 19 through its funding arrangement with its donors also has to comply with certain principles of transparency, put information on where we get our own money from on our website, and also how we're spending it. Our third principle is the promotion of open government, and generally tackling the culture of secrecy that tends to exist within governments, especially in the early stages of adopting access to information legislation, improving data retention and storage capacity, and public education to make people aware of the fact that they have the right of access to information and how they can assert it. One problem that comes up, and it's specifically been a problem in Nigeria, which adopted a Freedom of Information Act just over a year ago now, was it 2010? But within the first 12 months of the act actually coming into force, they received 0 information requests, which shows that legal responses to try and increase information flows aren't necessarily enough by themselves if nobody knows about them. And that comes under the promotion of open government. The right to access information, it's also important to understand that it's not an absolute right, that it can be limited. There's a 3-part test that applies to this, and it's generally when a government department is requested information and refuses to disclose it, it should firstly cite a legitimate aim for not disclosing the information. That might include on grounds of national security and public safety, but they'd have to give specific reasons as to why they're not disclosing. The harm test is that will substantial harm be caused by that disclosure? And then the public interest test is asking the question whether, despite the substantial harm, there's such a great public interest in information being disclosed that they should nevertheless go ahead and disclose it and let the harm happen. Processes to facilitate access. So this is sort of procedural elements that should be in place to facilitate access, including speediness and effective access, access to appeals, the establishment of information commissions that can process those rights, limited costs to make access affordable. And that's particularly important in the development context, where obviously you're trying to facilitate the right for people that often don't have access to a lot of money. The others on open meetings, the fact that meetings should be generally should be public. If they're not, it should satisfy that three-part test we just talked about. And the principle that disclosure takes precedence. So whatever the competing interests are, unless they fall within that three-part test, the default should always be disclosure. And this should be complemented with protection for whistleblowers legislation. So where people are operating within a government department and in good faith want to blow the whistle on corrupt practices, then access to information legislation also often includes protection for whistleblowers, or that protection is contained elsewhere. So domestic implementation. More than 100 countries have now adopted access to information laws. In 1990, this figure was 13 countries. In Africa, that number is 10. So Africa is one of the continents that really is underrepresented, which this map, which is available on Article 19's website and was released a few weeks ago, demonstrates. You can see that Kenya is one of the countries without access to information legislation at the moment, and it's really North Africa, the Middle East, and Sub-Saharan Africa are really underrepresented in terms of countries that have adopted access to information legislation. This map covers domestic legislation. A lot of these countries will have constitutional rights of access to information contained in their constitutions, but haven't implemented that at the domestic level. So effectively, the right is impossible to assert because you've not got any legislation containing these principles we've just talked about that allow you to effectively exercise that right. So we've talked about the cultural changes that have to happen within institutions when access to information legislation is adopted. Okay, so in addition to protection for whistleblowers, what we often see as obstacles to the media, especially the media reporting on corruption, which would include around development practices, is national security or national secrets laws being used to not only prevent access to information, but to disproportionately punish people who violate quite vague provisions on protecting national interests. There's also criminal and civil defamation. Article 19 has done a lot of work on both seeking to repeal criminal defamation laws around the world, and also civil defamation. While in itself we don't have a problem with it, in many countries it is used to impose astronomical damages sums on parties that attempt to expose corruption, and people accused of that corruption assert their right to reputation to get astronomical damages from people and silence the media. This is especially a problem in, I think, everywhere, but particularly in Sub-Saharan Africa, where the media is so grossly underfunded that you can throw a journalist in prison and an editor's probably not going to care so much. But if you put an astronomical damages and costs order on a newspaper, you're going to bankrupt them and they're not going to be able to continue their operations. In the same community groups, with the intention of testing how bad the situation is in different regions in terms of different information requests, depending on what kind of information people are trying to get, mapping how successful those information requests are, and then suing the government based on Article 35 of the Constitution if their information rights just flagrantly aren't being protected as they should be under the Kenyan Constitution, which was adopted incidentally in 2010 following the last most severe round of election violence. So that's my presentation. Hand over to Mark from Panos to say his bit. Thanks for listening.